Welcome to This Explainer. Today, we're diving into a landmark South African legal showdown that started with just one suspended lawyer and somehow snowballed into a massive national debate about the very future of the justice system. We're looking closely at the July 2002 Constitutional Court case of Van der Spuy versus the General Counsel of the Bar of South Africa. It's a truly fascinating look at how a single disciplinary issue can completely crack open complex questions about transformation, access to justice, and the strict rules that govern our courts. To make sense of this constitutional saga, we're going to break it down into 5 key parts: the suspended advocate, the referral rule, a constitutional battle, seeking direct access, and finally, why the court said no. Let's get right into it. Section 1, the suspended advocate. Let's look at the incident that actually kicked this whole thing off. It sounds completely counterintuitive, right? I mean, if you're a professional, you generally want clients to come straight to you. But we have to start with this exact question. Can a legal advocate actually get suspended from practice just for taking a client's money and instructions straight off the street? Well, based on the specific setup of the South African legal profession at the time, the answer was a resounding yes. Here's how it all went down. Our applicant is Adriaan Secundus van der Spuy, a high court advocate and a member of the Independent Advocates Association of South Africa. Back in April 1998, the High Court in Pretoria found him guilty of unprofessional conduct and suspended him from practice for 6 months. Naturally, he tried to appeal, but in September 2001, the Supreme Court of Appeals shut him down and dismissed his petition. Now here is where it gets highly unusual. Instead of taking the normal legal route to appeal to the Constitutional Court, he basically ignored the standard playbook. Then, out of nowhere in 2002, he reappears applying for something called direct access to the highest court in the land. Moving on to Section 2, the referral rule. To understand the suspension in the first place, we really need to unpack what this rule actually is. The whole case hinges on this, the referral rule. The General Counsel of the Bar, or the GCB, brought the initial complaint against Van der Spuy because he broke this highly specific rule. Basically, it strictly bans advocates from taking instructions or fees directly from members of the public. Instead, it requires that advocates must be briefed, meaning hired and instructed, by an attorney. You could think of attorneys as your general practitioners, the ones you go see first, and advocates as the specialists they call in later. Van der Spuy, he just bypassed the attorney entirely. Now, in his application, Van der Spuy didn't just argue this rule was annoying, he went big. He claimed it was flat out unconstitutional. He pointed to Section 22, the guarantee that every citizen has the freedom to choose their trade or profession. He brought up Section 34, everyone's right to a fair public hearing. And he even cited Section 35(2)(b), the right of a detained person to choose and consult a legal practitioner. He was essentially arguing that this referral rule was a massive roadblock, not just to his own career, but for the public's right to actually access justice. That brings us to Section 3, a constitutional battle. It is wild how fast this one disciplinary issue snowballed into a full-on national debate. The Chief Justice invited interested parties to weigh in, and wow, did they ever. 2 major heavy hitters jumped into the fray with completely opposing views. On one side, you've got the Minister of Justice stepping up, filing an affidavit arguing that the referral rule actively prejudices the entry of young Black and female advocates trying to enter the profession. The minister also contended it unreasonably drives up litigation costs for the public, basically acting as a financial gatekeeper. But on the flip side, the General Counsel of the Bar pushed back hard. They weren't claiming the system was flawless, but they argued that the difficulties faced by young practitioners and the need to fix race and gender imbalances are incredibly complex issues. Their point was you can't just throw assertions at the highest court. These are heavily disputed cost factors and transformation issues, and they require hard, factual trial evidence to properly resolve. And to really highlight the nuance here, advocates for transformation, specifically their Western Cape branch, intervened with a totally fascinating perspective. Their chairman agreed that Black and female entrants face huge hurdles. And yeah, the referral role plays some part in that. But he dropped this crucial quote. It is somewhat of a myth to think that if the referral rule is abolished, then the floodgates of work will open up for struggling Black and female advocates. They hit the nail on the head. The root causes of inequality in the legal system run way deeper than just one rule. Simply axing it wouldn't be the magic wand some assumed it would be. All right, Section 4, seeking direct access. With stakes this massive, you'd expect a blockbuster constitutional ruling on the rule itself. But a huge procedural curveball derailed everything. Remember how Spuy bypassed the normal appeal process after his Supreme Court of Appeal petition was dismissed? Well, instead of filing a standard appeal under Rule 20, he tried to use what's known as direct access to the Constitutional Court under Rule 17. And let me tell you, the court makes it crystal clear this is an extraordinary procedure. You do not just use this for your everyday legal battles. To pull off this shortcut, an applicant has a really heavy burden. Step 1. You'll have to lay out facts proving it's squarely in the interests of justice to just leapfrog the High Court and the Supreme Court of Appeal. Step 2, the Constitutional Court has to weigh the importance of the issues and the potential time saved against a huge red flag, the fact that they don't have a factual record from a lower court. And Step 3 is the reality check. Direct access is generally only granted in truly exceptional circumstances. The Constitutional Court is the highest court in the land. If every major issue went straight to them as a matter of course, they'd be bogged down trying to figure out disputed facts without the benefit of prior witness testimony or evidence. Which leads us perfectly into Section 5, why the court said no. Get ready for a firm masterclass on why legal procedure is just as vital as grand constitutional principles. Deputy Chief Justice Longa, writing for a unanimous court, completely shut Spuy's application down. Why? First, the General Counsel of the Bar pointed out, with very good reason, that this looked like a disguised appeal, a sneaky way to bypass his own unexplained failure to use the normal Rule 20 process back in 2001. But the much bigger issue was the missing facts. Because he skipped a trial process for these new constitutional claims, the highest court literally lacked a factual record. He was asking them to rule on massive disputes of fact, like whether the rule actually drives up costs or exactly how it impacts transformation, without any hard evidence properly tested in a high court. Plus, the court noted this whole debate over the referral rule was already happening in much more appropriate forums. The Legal Practice Bill was actively being promoted, and the Competition Commission was already locked in litigation with the Bar Council over the exact same rule. Deputy Chief Justice Longa really summed up the court's relationship beautifully by quoting a previous judgment. He said, "It is a matter preeminently for the SCA to determine, and it would not ordinarily be appropriate for this court to deal with such an issue as a constitutional matter without knowing the views of the SCA." Basically, the regulation of the legal profession is something the Supreme Court of Appeal has always had inherent jurisdiction over. The Constitutional Court essentially said, hey, we actually value the expertise of the lower courts, and we are not going to leapfrog them just because a constitutional right is mentioned. So, what is the crucial takeaway from this entire explainer? It's really the clash between two massive forces. On one side, you have this urgent, deeply substantive debate about legal transformation, racial and gender equality, and making justice affordable for the public. Everyone acknowledged that mattered. But on the other side, you hit an absolute brick wall of procedural reality. Bypassing the lower courts means the highest court lacks the verified facts and evidentiary records needed to make a sound decision. Like Lange noted, you just can't decide complex, society-altering disputes based merely on a few assertions in an affidavit. Which leaves us with a final, somewhat provocative thought to mull over. We all want a fair, accessible, transformed justice system, right? But can a legal system truly and effectively transform if it abandons the very strict procedural rules designed to keep those decisions fair and factual in the first place? It's a super delicate balance between the urgency for change and the integrity of the process itself. Thanks so much for joining me on this explainer. Keep questioning, keep analyzing, and I'll catch you next time.